Imagine this. You owe a small debt, maybe a couple of $100 for some vegetables, or perhaps a small loan you took out.
Okay.
Now imagine losing your entire home, the very place you and your children live, over that debt. Does that sound fair? I mean, does it sound right to you?
It's a really chilling scenario, isn't it? Yeah. It instantly highlights the profound human stakes involved when, legal processes bump up against fundamental rights.
Absolutely. And that very scenario brings us right into the heart of today's deep dive. A landmark South African constitutional court case, Jaftha v. Schoeman, Van Rooyen v. Stoltz. And this isn't just some dry legal battle. It's actually a powerful human story that fundamentally reshaped how justice is understood and, well, applied for the most vulnerable people in South Africa.
Yeah, our mission today is really to unpack this pivotal case. We'll delve into the key legal issues that were at play, explore the powerful arguments from both sides, dissect the court's reasoning and its ultimate decision.
And
crucially, understand what this ruling means for ordinary people and really the very fabric of justice. It's a deep dive into how two vulnerable women's struggles managed to escalate a critical constitutional question all the way to the highest court in the land.
So let's begin with the human stories, because that's truly what anchors this entire case. We can start with Miss and Maggie Jaftha. Her situation was, well, pretty dire.
Yeah.
Unemployed, battling ill health heart problems, high blood pressure, living in poverty, and with only a standard 2 education. Very basic.
And she'd received a state housing subsidy back in 1997.
That's right, a genuine lifeline for her, which allowed her to buy a home where she lived with her 2 children.
Okay, and this is where her struggle with debt began, I assume.
Exactly. In 1998, Mrs. Jaftha borrowed just R250. Despite making some repayments, the debt escalated because of interest and costs up to R632.45.
So still not a huge amount in the grand scheme of things, but growing.
Right, but growing. She actually continued making payments, but then a crisis hit. She was hospitalized. When she finally returned home, she received devastating news. Her house was going to be sold in execution.
Oh, wow. Over that amount.
Well, she was told she needed to pay R$5,500. Then later it jumped to R$7,000, which was, in her own words, way beyond her means.
Completely unaffordable for someone in her position.
Totally. And tragically, her property was eventually sold for R$5,000, and she was forced to leave her home.
Just heartbreaking. A truly awful sequence of events.
It really is. And Miss Christina Van Rooyen's situation echoed Mrs. Jaftha's in many ways.
Correct.
She, too, was unemployed, poor, had never even been to school, and was supporting 3 children.
Right. And her housing situation.
Her late husband had acquired their home back in '97 with a state subsidy about R$15,000 that time, and she inherited it after he passed away. So again, state-subsidized housing.
Okay, similar starting point. And the debt.
Even smaller initially. In 1995, Mrs. Van Rooyen purchased some vegetables on credit for approximately R$190.
Vegetables, wow.
Yeah. This debt, much like Miss Jaftha's, spiraled with interest and costs, eventually reaching just R$198.3.
Under 200 Rand.
Under 200 Rand. And yet her home was then sold in execution for a mere R$1,000.
1,000 Rand.
1,000 Rand on the very same day as Mrs. Jaftha's home was sold.
That's staggering. As you look at these two women's stories, what immediately strikes you as the most significant common thread?
Well, the parallels are just glaring, aren't they?
They really are. Both women were clearly indigent, living in extreme poverty.
Right. Both relied entirely on state housing subsidies, which, as you said, is often a once-in-a-lifetime shot at secure housing for many people.
And critically, both faced losing their homes, their only secure refuge, over incredibly small debts, especially when you compare it to the value of the property or just the human cost.
Yeah, absolutely. And it also came out in court that both had other unsatisfied judgments against them. Mrs. Jaftha had 4 others, Mrs. Van Rooyen had 2. So they were clearly struggling financially on multiple fronts.
Right, which paints an even more desperate picture. It wasn't just one isolated debt problem.
No. And it's also worth noting the role of Marcotter attorneys here.
Ah, yes, the local attorneys.
They were the only firm operating in Prince Albert, initiating these proceedings for creditors against both women. Now, the court didn't confirm the specific allegations, but it did refer concerns about potentially unreasonable deadlines and aggressive conduct.
Right. Refer them to the Law Society for investigation.
Exactly. Which certainly makes you think about how debt collection processes can impact vulnerable people in practice, doesn't it?
It absolutely does. I mean, that referral itself highlights the court's broader concern for fairness within the whole legal system, not just the letter of the law.
So with these really powerful human stories in mind, let's talk about the legal landscape. What was the core legislation that allowed for these kinds of devastating outcomes? What exactly was being challenged?
Okay, so the foundational law under scrutiny was the Magistrates Courts Act 32 of 1944. Quite an old piece of legislation, actually. Specifically, Section 66(1)A was really at the heart of the challenge. This section basically laid out the process for debt recovery. If a court gave a judgment for money and the debtor didn't pay.
Or couldn't pay.
Or couldn't pay, right. Execution would first happen against their movable property.
Yeah.
You know, furniture, maybe a car if they had one.
Okay, standard procedure so far.
Standard procedure. But if there wasn't enough movable property to cover the debt, what's formally called a nulla bona return by the sheriff.
Meaning no goods found.
Precisely. Then execution could proceed directly against immovable property.
Like a house. And this is where it gets really problematic from the perspective of Mrs. Jaftha and Mrs. Van Rooyen.
Exactly. The critical flaw the appellants, their legal team, identified was this. For default judgment, so where the debtor didn't even defend the claim, maybe he couldn't afford to, or didn't know how, or for liquidated debts, meaning easily calculated debts. This entire process of moving from movable to immovable property, including the sale of the house, could happen without any judicial oversight on that specific decision to sell the house.
Wait, so no judge actually looked at it and said, okay, considering everything, selling the house is the right call here?
Not necessarily at that crucial step. It was often handled by the clerk of the court. More of an administrative function, really.
That's astonishing. So under that old system, someone's home could effectively be sold without a judge ever weighing the individual circumstances. That sounds like a massive gap, especially for vulnerable people.
It really was. And it was precisely that lack of judicial discretion, that missing step of a judge looking at the whole picture, that became the focus of the constitutional challenge.
Okay. And there was another section mentioned, Section 67.
Yeah, Section 67. This part of the act listed specific things that were exempt from being seized and sold. Essentials like necessary beds, clothing, food for a month, tools of trade up to a certain value.
Basic necessities.
Exactly. The appellants argued that this section was also unconstitutional because it didn't include the debtor's home in that list of protected items. They saw a basic home as just as fundamental a necessity.
Which logically brings them to the main constitutional challenge, right? The right to adequate housing.
Precisely. Section 26 of the South African Constitution.
Okay, so Section 26(1) says, everyone has the right to have access to adequate housing. Pretty clear statement. How did the appellants connect the mechanics of Section 66(1), that process of selling the house, to this fundamental constitutional right?
Well, their argument was powerful and quite direct. They argued that Section 66(1)A was unconstitutional precisely because it allowed for the removal of existing access to adequate housing.
So it wasn't just about the state providing housing, but about the state taking away housing that someone already had.
Exactly. Even when that removal might be unjustifiable in the circumstances. And this was particularly significant, they argued, for state-subsidized homeowners. Because if they lost their homes this way, they could potentially be barred from getting future state housing assistance.
Oh, so it could trap them in a cycle of homelessness? Lose your subsidized house, and you might not be able to get another one?
That was the fear, yes. It could have devastating long-term consequences.
And this sounds like it ties into broader international human rights principles too, doesn't it? It's not just a South African issue.
It absolutely does. You have things like Article 11 of the International Covenant on Economic, Social, and Cultural Rights, and the UN Committee's General Comment 4. These strongly emphasize the right to live somewhere in security, peace, and dignity.
Security, peace, and dignity. That's powerful phrasing.
It is. And they stress the importance of security of tenure, which goes beyond just legal ownership. It's about feeling secure in your home. This aligned perfectly with the appellant's arguments that losing your home fundamentally undermines that security and, importantly, your dignity.
And that emphasis on dignity really resonates, particularly in the South African context, given the history. Can you elaborate a bit on how Section 26 specifically aims to address those historical injustices related to housing from the apartheid era?
Absolutely. Section 26 is, in many ways, a direct response to that history. During apartheid, security of tenure was systematically denied to the majority of South Africans based on race. You had widespread forced removals, racist evictions.
Communities destroyed.
Exactly. People were often removed from land they'd occupied for generations, sometimes even branded as criminals simply because of their race. This denial of housing wasn't just about shelter. It was a profound assault on human dignity, on people's sense of self-worth.
So Section 26 is trying to reverse that legacy.
Yes, it directly counters that history. It strives to provide access to adequate housing for everyone and, crucially, ensures people aren't removed from their homes unless it's legally sound and genuinely justifiable, considering all factors. It explicitly links housing to inherent human dignity. It makes this case about far more than just, collecting debts.
Right. It elevates it to a fundamental human rights issue. So with these strong constitutional arguments laid out, how did this actually play out in the courts? Mrs. Jaftha and Mrs. Van Rooyen first went to the Cape High Court, right? Trying to set aside the sales and stop their eviction.
That's right. And interestingly, most of the other parties involved the creditors, Marquardt or attorneys. For some aspects, they either settled or withdrew their opposition.
So it mainly came down to the applicants versus the government?
Pretty much. It was primarily the Minister for Justice and Constitutional Development who opposed the constitutional challenge itself. The minister initially argued, look, the non-constitutional issues like the specific sales are settled, so the court shouldn't even get into the constitutional questions now.
Trying to avoid a ruling on the act itself.
Seemingly, yes. But the High Court, quite wisely, I think, rejected that argument. They recognized the ongoing risk to the appellants and others like them because of those other outstanding debts. As long as Section 66(1) remained on the books as it was, their homes were still potentially in jeopardy.
Okay, so the High Court agreed to hear the constitutional challenge, but their initial reasoning on Section 26 was quite different from where the Constitutional Court ended up, wasn't it?
It was indeed quite distinct and became a key point of contention later. The High Court essentially held that the right to housing under Section 26 doesn't automatically mean a right to ownership of one specific home.
How do they justify that?
They reasoned that the actual loss of occupation wasn't directly caused by the execution process itself, but rather by, say, the debtor choosing to leave, or by separate eviction proceedings, which would happen under a different law, the PIE Act.
So they were separating the sale from the physical removal.
In a way, yes. They saw the execution sale under Section 66 as distinct from the potential eviction later. Therefore, the High Court concluded there was no violation of Section 26 caused directly by Section 66(1).
That feels like a very narrow, almost technical interpretation of the right to housing. So the appellants obviously weren't satisfied and took their case up to the Constitutional Court.
Exactly. They appealed, seeking the same relief, setting aside the sales, preventing eviction, and getting the act declared unconstitutional. And at the Concourt level, they also broadened their arguments, formally bringing in Section 10, the right to dignity, and Section 25(1), the right against arbitrary deprivation of property.
Though the court didn't end up needing to rule on those separate rights.
Correct. Ultimately, the Constitutional Court found it could resolve the case based purely on Section 26, the right to housing. So it didn't make findings on the dignity or property rights arguments in the end.
Okay. And what about the minister's counter-arguments at the Constitutional Court? What was the government's defense of the act's constitutionality?
Well, the minister emphasized, look, debt recovery is vital. It's crucial for the administration of justice. It underpins commercial transactions. They argued it's especially important for poor people who might need access to small loans just to get by. If creditors can't recover debts, they might stop lending altogether.
A practical economic argument.
Yes, and they also pointed to what they saw as existing safeguards within the Magistrates Courts Act itself. Specifically, Section 62, which allows a debtor to apply to the court to stay or set aside a warrant if they can show good cause, and Section 73, where a debtor can ask the court to let them pay off debt in installments.
So the government was saying there are already mechanisms, debtors just need to use them.
Essentially, yes.
Yeah.
That the tools were there, maybe just not always used effectively.
Right. This sounds like the point where the Constitutional Court really made its mark. What was their critical turning point in reasoning, especially regarding Section 26 and that High Court interpretation?
This is absolutely where the court introduced a truly transformative understanding. It directly challenged that narrow High Court interpretation of Section 26. The Constitutional Court firmly affirmed that socioeconomic rights, like the right to housing, have a crucial negative obligation.
Okay, unpack that for us. Negative obligation.
It means that the state doesn't just have a positive duty to take steps to provide access to housing, which often depends on available resources. It also has a negative duty and obligation not to do things that would unreasonably prevent or impair someone's existing access to adequate housing.
So if I'm understanding this right, the court isn't just saying the state should ideally help people get housing, but that it actively cannot unjustly take away the housing someone already has, even if the state didn't provide it directly. That feels like a really significant shift.
It is a very significant shift.
Right.
It means the state, and potentially even private parties in some situations, have this fundamental duty not to interfere unjustly with existing access to adequate housing. And importantly, this negative obligation applies generally even if state resources aren't the main issue, unlike positive obligations, which are often qualified by resource availability. It's about protecting what people already have secured.
That's a powerful distinction. Okay, so armed with this concept of a negative obligation, the court then applied the standard constitutional test for limiting rights, right, Section 36 of the Constitution. How did they balance the government's point about needing debt recovery against this newly emphasized negative right to housing?
Exactly. They moved to the Section 6 limitations analysis. They acknowledged straight up that debt recovery is important for a functioning economy and justice system. No question about that. But they found that the potential for someone losing their home, often their only significant asset and source of security over what they termed a trifling debt, constituted a really severe limitation of an important right.
Especially for indigent people.
Especially for indigent people, yes. Because, as we discussed, if they lost their homes, particularly state-subsidized ones, they might never regain access to similar housing assistance. It could effectively condemn them to long-term homelessness. The consequences were just too severe.
Now, it must have been tricky for the court to define trifling debt, because surely what's trifling to one creditor isn't to another.
Absolutely. The court explicitly grappled with that. They acknowledged that trifling is inherently subjective and depends heavily on the creditor's circumstances as well as the debtor's. R500 might be insignificant to a large bank, but critical for a small shopkeeper.
So they didn't set a specific RAND value.
No, they didn't. Instead, they stressed the need for a careful balancing act in each case, weighing the creditor's legitimate interest in recovering the debt against the immense prejudice and hardship the debtor would suffer if they lost their home. They also highlighted the potential for abuse of the process by, unscrupulous creditors using it as a tool for leverage over small debts.
Okay. And what about those existing safeguards the minister pointed to, Sections 62 and 73, applying to stay the warrant or pay in installments? Why did the Constitutional Court find those weren't enough?
The court looked at the practical reality. They found those existing safeguards were simply inadequate in practice for the most vulnerable. Why? Because, as Ms. Jaftha and Mrs. Van Rooyen's cases illustrated, indigent debtors are often completely unaware these provisions even exist.
Or they can't afford a lawyer to help them use them.
Exactly. Even if they are aware, they frequently lack the financial means or the knowledge to navigate the legal system and actually invoke those sections effectively. So the court concluded that the existing scheme under Section 66(1)A was overbroad.
Meaning it swept too widely.
Yes. It permitted these potentially unjustifiable sales without sufficient judicial intervention built into the process itself, especially for undefended or easily calculated debts. It was too blunt an instrument, catching cases where selling the home was grossly disproportionate.
Got it. And just quickly, regarding Section 67, the part listing protected movable assets. Did the court consider the appellant's idea of adding homes below a certain value to that protected list?
They did consider that suggestion a blanket prohibition on selling homes below a certain value. However, the court ultimately decided that such a measure would not be appropriate.
Why not? It seems like a simple fix.
Well, their reasoning was that it could inadvertently create what they called a poverty trap. It might prevent poor people from using their homes, often their only significant asset as security, to raise capital if they desperately needed it, say for a small business or a family emergency. And it could also unfairly hinder creditors from recovering legitimate debts altogether in some cases. So they preferred a solution involving judicial oversight rather than a blanket ban.
Okay, that makes sense. So after weighing all these complex factors, the human stories, the constitutional rights, the practicalities, what was the court's ultimate decision, and how did it fundamentally transform the legal landscape for debt recovery against homes?
The court's decision was indeed transformative. It declared Section 66(1)A of the Magistrates Courts Act unconstitutional and invalid.
The whole section.
No, crucially, only to the extent that it allowed execution against the immovable property. So, homes of judgment debtors without prior judicial oversight. It targeted that specific procedural gap.
Okay, so it zeroed in on the lack of a judge's involvement. And how did the court remedy this? Did they strike down the section and tell Parliament to fix it, or did they provide an immediate solution?
They provided an immediate solution, which is quite common for the Constitutional Court when it can. To fix this defect, the court opted to read in words directly into Section 6676. They essentially rewrote part of the section.
Rather than suspending the order and waiting for Parliament.
Exactly. They wanted to provide immediate protection. The crucial new wording now effectively says, if there isn't enough movable property found, then a court, after consideration of all relevant circumstances, may order execution against the immovable property.
A court may order execution. That's the key change.
That is the absolute key. What this means for you, the ordinary person, is monumental. Now, if not enough movable property is found to cover a debt, the creditor must go back to a court, specifically apply to a judicial officer to seek an order allowing the sale of your home.
So it's not automatic anymore.
Absolutely not. This crucial step ensures judicial oversight. It prevents those automatic sales by the clerk that could, and clearly did, lead to homelessness over relatively small debts, without anyone properly considering the proportionality of it all. And it wasn't just about adding that procedural step. The court also gave really vital guidance on what factors a judicial officer, like a magistrate, must consider before they can grant such an order to sell someone's home.
Right, because just having oversight isn't enough if the judge doesn't know what to look for. What kind of factors did they list?
Well, first, basic procedural compliance, making sure everything was done correctly up to that point. Then, crucially, exploring whether other reasonable ways exist for the debtor to pay the debt.
Like those installments under Section 73.
Exactly. Could installments work? Is there another way short of selling the house? And then, critically, assessing whether there's a gross disproportionality.
Okay, what does that mean in practice?
It means the magistrate has to weigh things up. Is the creditor's legitimate interest in getting paid significantly outweighed by the debtor's interest in keeping their home, their security of tenure? Especially, the court emphasized, if losing the home would result in complete homelessness.
So the size of the debt would definitely be a relevant factor there, even if trifling itself is subjective. What else should a magistrate be thinking about?
Other really critical considerations include the specific circumstances of how the debt was incurred. For example, was the home itself put up as security for the loan? That might weigh differently.
Makes sense.
They also need to look at any efforts the debtor has already made to pay, the financial situation of both parties, not just the debtor's employment status or income potential.
So a really holistic picture.
Yes. And the court strongly emphasized finding creative alternatives wherever possible, rather than just jumping straight to execution against the home. It's meant to be a thoughtful balancing process, definitely not just rubber stamping the sale anymore.
That's a huge shift. Finally, the court also took a very specific action regarding Marcotter Attorneys, the firm involved in Prince Albert, didn't it?
It did, and this was quite pointed. While the court reiterated it wasn't making a finding on the truth of the allegations against Marcotter Attorneys regarding their conduct.
The ones about unreasonable deadlines and aggressive tactics.
Those ones, yes. But the court explicitly referred the seriousness of the allegations to the Law Society of the Cape of Good Hope for a formal investigation.
Which sends a pretty clear signal about accountability.
Absolutely. It underscores the judiciary's commitment not just to fixing laws, but also to ensuring ethical conduct within the legal profession itself and protecting vulnerable individuals from potential abuse of the legal process.
So let's try and bring it all together. What's the real lasting legacy of the Jaftha case? How does this fundamentally change the landscape for debt recovery and housing rights in South Africa?
I think the Jaftha case fundamentally transformed that landscape. It shifted debt recovery impacting homes from what was often an almost automatic administrative process, potentially driven just by a clerk of the court, to one that now requires a judicial officer, a judge or magistrate, to actively weigh all the human factors involved before someone's primary residence can be taken and sold.
It put humanity back into the process, in a way.
You could definitely say that. It mandated consideration of the human cost.
And if we connect this back to the bigger picture of constitutional rights, what's its broader significance beyond just debt collection?
Oh, its broader significance is immense. First, it really solidified that understanding of the negative obligation inherent in socioeconomic rights. It clarified that the Constitution doesn't just ask the state to provide things like housing, but also demands that it protects people's existing access to fundamental rights, like housing, from unjust interference.
A shield, not just a promise of future help.
Exactly. Second, it profoundly affirmed the inherent link between housing and human dignity, which is especially crucial in a country like South Africa, with its specific history of dispossession and forced removals. It recognized that a home is more than just bricks and mortar.
And ultimately, then, it provided a vital layer of legal protection for the most vulnerable members of society.
Yes, ensuring that the legal system itself doesn't unintentionally become a tool that exacerbates poverty and homelessness. It forces the system to pause and consider the real-world impact before taking such a drastic step.
So perhaps final thought for our listeners to mull over. This case really forces us as a society to consider a fundamental and ongoing question. When does the legitimate right to collect a debt end and the fundamental human right to dignity and a place to call home begin?
And perhaps even more complexly, who bears the responsibility, the courts, the legislature, creditors, society as a whole, for thoughtfully and justly balancing these two absolutely crucial aspects of a fair society? It's a question Jaftha answered in one context, but it keeps arising in new ways.